Welcome. On behalf of the Center for the Study of Race and Law at the University of Virginia School of Law, I'm very excited to welcome you to our panel, Multi-Million-Dollar Verdicts and the Influence of Race. Our panel is going to explore how race influences civil jury trials, as well as negotiations and mediations. Why this topic, and why now? Many of our current students will eventually serve clients whose interests can only be advanced through litigation. Being a successful litigator means that you need a deep understanding not just of your client's needs, interests, and vulnerabilities, the substantive law that governs their claims, as well as, of course, the procedures that you can use to vindicate that claim. But it also includes understanding the influence of race in a world where race still matters. It influences our human interactions in both systemic and individual ways. Understanding how it matters for young lawyers helps them to develop a holistic approach to litigation that recognizes this reality. Today, we have a distinguished panel of attorneys and social scientists to discuss these important issues. Each panelist will deliver opening remarks of no more than 18 minutes, and then I will ask a couple of questions before opening it to the audience. And I'm going to introduce them in the order in which they will be speaking. James Carter is a nationally accomplished and award-winning attorney, statesman, educator, and author who's been practicing for over 25 years. He's the managing partner of the Cochran firm, Trials and Mass Torts, and serves on the Cochran Firm's National Board of Directors. He is presently the Vice President of Finance for the National Bar Association. Mr. Carter is a formidable trial attorney who's responsible for recovering millions of dollars on behalf of clients, both personal and corporate, throughout the United States. His skillfully aggressive approach to civil jury trial gained him elite membership in the Multimillion-Dollar Advocates Forum. He's also received certification from the Mass Tort Multi-District Litigation from the Bulk Judicial Institute and at Duke University School of Law, and a 2021 certificate in Governing for Nonprofit Excellence from Harvard Business School. For his accomplishments as an attorney and public servant, Grambling State University and the University of New Orleans awarded him honorary doctorate degrees. He's also taught civil trial litigation at Howard University School of Law and Tulane University School of Law. Mr. Carter earned his undergraduate degree in philosophy from Howard University and his law degree from Howard University School of Law, where he currently serves on the Board of Visitors. Karen Evans. Ms. Evans is a distinguished and award-winning attorney, accomplished speaker, published author, and commercial actor whose career spans more than 3 decades. She's a partner and shareholder at the Cochran Firm's Washington, D.C. office, where she serves as Director of Medical Malpractice and co-chair of the National Cochran Firm's Medical Malpractice section. She's also one of 9 members of the firm's Board of Directors. As the face of the Cochran Firm in D.C., Maryland, and Virginia, she leads the firm's presence and reputation throughout the region, representing its values, vision, and excellence in high-profile legal matters. Ms. Evans has earned a national reputation as a dynamic and highly influential attorney. Her track record includes consistent success in high-stakes litigation, having developed a reputation for handling multi-million-dollar cases in the 7- and 8-figure ranges. Before launching her career, Ms. Evans served as a captain in the United States Air Force Nursing Corps, specializing in medical, surgical, and intensive care nursing for a decade. She earned her BS in nursing from East Carolina University and began her legal education at Texas Tech University School of Law, where she was selected for the law review. She eventually transferred to the University of North Carolina School of Law at Chapel Hill, where she earned her law degree. And last but not least, I have Dr. Leslie Ellis. Dr. Ellis has been conducting research on jury, judicial, and arbitrator decision-making for over 25 years. So you can see that the key thing that I had for all the panelists was a long, distinguished career working on these issues. She has consulted on hundreds of cases across the United States, U.S. territories, and internationally. She works with clients on high-risk and complex cases in all industries and areas of litigation. In providing advice to her clients, she relies on years of studying legal decision-making through academic research, mock studies, post-trial interviews, and field research on real juries. She also uses her research training to develop programs of qualitative and quantitative research designed to help clients make those difficult decisions that arise in every case. Dr. Ellis earned her BA in psychology from Northwestern University. She graduated with her master's degree and a PhD in social psychology from the University of Illinois at Chicago. So first up, we will have Mr. James Carter.
Thank you so very much, Professor Robinson. Thank you so much, and thank you for this opportunity to present today at this wonderful and distinguished and elite university. This is a wonderful topic, a very wonderful topic. Multi-million-dollar verdicts and the relevance of race is a very, very interesting topic, and we're going to explore different ways that race affects the outcome of high-end litigation. I am from New Orleans, and we just came back from Mardi Gras season, and I am exuberated and excited, and it's a good time to talk about the magistry in the theater of the courtroom, if you will, coming out of the theater of Mardi Gras. So many of you heard of this guy. His name is Aristotle, right? Aristotle, as some of you know, was a Greek philosopher, and he wrote as many as 200 treatises, but more importantly, for purposes of this particular lecture, Aristotle developed a formalized system for reasoning. And he's particularly known for his work on rhetoric in particular. Aristotle came up with 3 pillars of rhetoric or persuasion. And I want to talk to you about that for a minute. He talks about ethos or credibility, logic or logos, and pathos, emotion. And out of the 3, just think to yourself, we can go call and response. I am from a Baptist church in Louisiana. But of those 3 components, talk to yourself and tell me which one of you all thinks that the first one is the most important, or the second element is most important, or the third element is most important. You don't have to tell me right now. We'll talk about that a little bit later. But I'm going to tell you that Aristotle said that ethos is most important, credibility, and the 3 pillars of rhetoric. That's important because when you are trying to relate to juries and be persuasive, a proper mix of credibility, logic, and emotion play an important role in maximizing jury verdicts. And when you look at it, this particular diagram shows the intersection between the 3, and right in the middle is a persuasive lawyer. It reminds me of gumbo, right? I'm from New Orleans. We love gumbo. But gumbo is known to be a great mix of all of these different ingredients, and the filet, and Gerard Robinson knows about that out of Lake Charles, Louisiana. It is so good. But in order for it to be that good, you have to have the proper mix. This is making me hungry, actually, right? But even though we're talking about the relevance of race, it's important to know that it doesn't matter what your race is, sex or creed, religion, etc. What's most important is the predicate of competence. Nothing satisfies a jury more than a lawyer being competent, but there are elements in addition to competence that are important to influencing juries. So there was a man, his name was Charles Hamilton Houston. Charles Hamilton Houston was known as the man who killed Jim Crow, first special counsel for the NAACP, developed the strategy that ultimately won the Brown v. Board of Education case, but I must put this pin in it. There's a lady named Pauli Murray. I want you to look her up. She actually was called one of the great leaders She was the number one in her class from Howard in 1942. But Thurgood Marshall, the student of Charles Hamilton Houston, said that she wrote what's called the Bible of the Civil Rights Movement, which is a book called States' Laws of Race and Color. That's another issue, but I had to put that in there. Dean Charles Hamilton Houston was so important because he's the one who really put and elevated Howard to be on the map. But in addition to being what's called a social engineer, right? He was famous for saying a lawyer is either a social engineer or parasite on society. We utilize that a lot, that particular saying, but he said a social engineer is a highly skilled, perceptive, sensitive lawyer who understands the Constitution of the United States, knows how to explore its uses in the solving of problems of local communities and in bettering conditions of the underprivileged. What I want to pinpoint to you is when you are a social engineer, if you want to become a social engineer, you must be highly skilled, right? So we're not talking about having a multicultural trial team for the sake of having it. You must be competent. You must be able to articulate in certain words and be special litigators in the sense of expertise. So how does race become an important part of garnering multi-million-dollar verdicts? Well, there's something called lived experiences as an African American in the courtroom. Not because you have genotypical features or genotypical aspects to an individual or phenotypical. It is a matter of your experiences that you bring to bear as an African American attorney or other ethnicities in the courtroom. So look at this guy right here. Isn't he a handsome guy? That's James Carter, right? That's James Carter at 1 and 5. I was so proud of my fro. Something happened to it along the way, but that's okay. Well, at that particular time, that was before I was touched by anything. You know, I was influenced, obviously, by things I don't remember right now. But along the way, I learned and I developed through experiences certain ways of thinking about things. This is James Carter at 16. That's me right there, just to get a closer look in case you can't see. That's him right there, right? That's me in the French Quarter of New Orleans conducting a human circus right there. I'm the ringmaster right there. That's one of my experiences. One of my experiences is being part of the African American church. And in the African American church, there are experiences that influence presentational styles, right? You get to know scriptures and you get to present in certain ways. In fact, I learned a lot about the courtroom by sitting in church, in particular the African American church. There it is. What a theater it is. How powerful it is, how exciting it is, and how inspirational it is. My experiences in the church. But also, I was the king of a Mardi Gras crew recently. That's me. That's with Al Roker right there. That was a few days ago, actually. Right? That's Al Roker. I was the first African American king of the Crew of Allah in its 93-year history. So that influenced my perception, right? The colors and the beautifulness and the majesty of Mardi Gras. But also, there are adverse lived experiences as an African American in the courtroom. Here's an incinerator that bellows out toxic fumes. Well, in my neighborhood, I grew up with an incinerator in my neighborhood, bellowing out smells and horrible smells and toxic chemicals in my neighborhood. One time I was going home, my friend and I, I had to be like 13 or 14 years old, was stopped by law enforcement for no apparent reason. There must have been some call that law enforcement had. And before even telling us to stop, the guy stopped us with his gun drawn. Thought I made the wrong move. I may not be here today. And that officer was an African American officer, by the way. Wasn't a white officer. Here it is in 1995. The 1995, May 3rd, 1995 flood in Louisiana. This is my neighborhood. That's my dad and my brother who are in New Orleans. And what you see there, that's water. We have a major flood in my community. But just down the block, in the white portion of my community, it didn't flood. Here's a train track going through an African American neighborhood in the city of New Orleans. Those are homes on both sides, right? So in 1987, there was a train derailment because my neighborhood was encircled by train tracks. So you have an incinerator, you have floods, you have a train track. I didn't even realize this stuff growing up, the relevance of it. So in 1987, that was my first semester at Howard University undergrad, there was this derailment. It turned into a class action where toxic fumes spewed into a neighborhood. My parents were affected. I was at school. But I remember these things, right? And it kind of affects the way I think about things. Okay, so here we go. How race brings value to multi-million-dollar verdicts. When you are assembling a trial team, in many cases, the jury pool as well as the broader courtroom will represent a multitude of faiths, races, genders, and beliefs. That's a mean-looking crew, right? Those folks are not interested in anything we have to say right now. We got to make it alive and make it relevant and talk about one's experiences, etc. So here we go. Great trial attorney named Russ Herman out of New Orleans wrote a book. And he said, in small towns throughout the country, trial lawyers were like stars in the theater. When courts were set, folks would drive or ride from miles around in their buckboards just to see the show and the trial lawyers played to us in the gallery as much as the jury. Some of them were flamboyant. Some lawyers had followings who bragged them up and told story after story about what they said and who they quoted. Most of the lawyers had read the Bible and the classics, and they can quote freely and did. Some of them had a story for every occasion, and the story would often make a point when nothing else would. It was those experiences that developed these personalities. So what is this? This is around August 2005. This is Hurricane Katrina. How many of you can raise your hand? How many of you heard of Hurricane Katrina? Well, we were living in New Orleans in Hurricane Katrina. My wife, my son, and I, my son was 4 years old at the time. We left New Orleans thinking we were going to return in 3 days. It ended up being 3 months we returned because the city was immersed in 9 feet of water, 80% of the city. Out of that event came a case called the Robinette case. Robinette versus LaFawn facility of the Holy Family. Well, but who is LaFawn Nursing Home? What is LaFawn Nursing Home, and who are the Holy Family members? Well, the Holy Family is the oldest order of African American nuns in the country. And these people are sacred, they are solemn, and they are extremely respected in the city of New Orleans. Unfortunately, we had to file a lawsuit against the Sisters of the Holy Family. LaFawn administration failed to provide a safe environment for our client to shelter in place and also failed to evacuate our client. 17 residents died, including our client, ended up dying because of that. Well, this is how race became relevant. It became relevant as an attorney because I had the sensitivity to understand who the Sisters of the Holy Family were. In New Orleans, we have the largest concentration of African American Catholics in the country. And this is a storied, very, very famous order of nuns. So my trial team hired me. They gave me the most difficult witnesses. And it was a Sister Benjamin. You remember that? It's my wife, by the way, Dr. Renee Carter. They gave me Sister Benjamin to cross-examine. Sister Benjamin was 84 years old, sweet lady, and she stayed. 84 years old, right? I had to be very, very careful, very sensitive because I understood because of my experience, not because of my intellectual superiority, because my genotypical features, but simply because of my experience. I was able to bring that to bear and handle it in a certain way that was respectful, that understood the very great cultures and the importance of this institution called the Sisters of the Holy Family, and it resulted in $1 million verdict. That part would have gone wrong, or you didn't understand that, but hurt the case in dire ways. We had another case where an individual lost his ability to ambulate. And when he lost his ability based upon the wrong tritation of medication, he was a boy at the time. He was an African American male, right? We had a multiracial trial team. They brought me on the trial team. Well, the gentleman who was going to do the opening statement on the matter, because the case was about 25 years old, the gentleman who was our client was now, at this particular time, he was in his 40s. But in practicing the opening statement, the non-African American attorney who was a part of my team, who didn't mean anything, he didn't mean any harm, he kept referring to him as a boy. He didn't know. And every time we talked, he said, well, he was a boy. No. You cannot refer to a grown African American man as a boy in the context of a jury pool when he's a man. He's a man. He's a young man. And I'm a young man too at 55, by the way. That's another issue, right? But I was able to pinpoint that to the trial team in a way that helped to craft it. We ended up moving him out the way, actually, putting another lawyer to present it. And it ended up being a situation that was good for everybody in the end. The relevance of race. We also had a situation on another case where we had the burning of a building for a school called St. Augustine, which is an all African American male school. We had it in federal court. I was able to bring that sensitivity. In fact, the entire trial team, except myself, had graduated from the school, so they knew the contours, et cetera, et cetera. But you bring a certain sensitivity based upon experiences to a diverse situation, okay? So race becomes relevant in a different way that you may not have expected based upon the title. From experience you can add to trial teams, which will make a difference. And we got a $6.35 million verdict last year on that particular case. This sensitivity is relevant in the voir dire, opening statements, the way you craft your opening statements, direct examinations, cross-examinations, rebuttal, closing arguments. I love closing arguments because in a closing argument, I'm able to talk about things that I can't talk about in the opening statement. Along the way, I can talk about and make persuasive arguments based upon my experiences, what I can quote, the history I knew about the Sisters of the Holy Family, about St. Augustine High School, about my experiences with my situations going from incinerators in my neighborhood, from train tracks encircling my neighborhood, from the floods that would happen in the neighborhood that didn't happen in other parts. So when I come to the table dealing with environmental discrimination, right? Dealing with issues of toxic fumes in neighborhoods, et cetera, because of my experiences that were differentiated from others in my circumstance, my race then becomes relevant to producing and causing multi-million-dollar verdicts because I'm able to humanize the situation in ways that others may not. But most important, those are great attributes, but most important is your competence. You must be competent, you must know what you're doing, and then you can add those other things on. Thank you.
I'm Karen Evans, and I'm going to add on to the discussion that James started about multi-million-dollar verdicts and settlements and how race plays a part in it. And as I was preparing for this talk, it dawned on me it permeates every aspect of the litigation. So what I do, I've been an attorney for about 30 years now, a little bit over that, and I only take cases that I think have a value of $1 million or more. And so what does that look like? Well, first of all, it's got to be severe, permanent, and life-altering injuries, significant economic damages, and the egregious nature of the negligence, like what went wrong. And most importantly, the at-fault party has to have the ability to pay. Because you can have a great case, but if there's no way to get the money, it's not going to be $1 million verdict or settlement case. So, race impacts every aspect of the litigation. In writing, I said many, but as I thought about it, it's like everything. Case selection, venue, well, you're in law school, I don't have to explain those terms. If I do, we got a problem. Venue, pretrial discovery, mediation, and trial. Those are stepping stones. All right, so let's talk about it. Race impacts access to legal representation. Well, what does that mean? Well, some lawyers won't take cases involving minority clients. Why? Because they think they're not going to get as much money. You still got to put in the same amount of work for whatever the result might be. And some and I'm not saying it's conscious, I'm just saying it happens. So, there we go. All righty, what's next? So why does that happen? So, you know, in our neutral legal system where race doesn't matter, and we have all of these rules that say race doesn't matter and everybody's fair and equal, it still happens. Because today, juries in tort actions, and I'm only talking about tort actions routinely consider the plaintiff's race when calculating compensatory tort damages, and they do it in a manner that systematically results in lower awards to black plaintiffs compared to white. That's not Karen Evans, that's what the research indicates. Why is that? Well, I'm going to talk about it, and I'm just going to talk about a few of the things that I think impact those decisions. First of all, there are legal rules in place that appear race neutral, but in the application, they are very much have negative impacts on people of color. I'm going to talk specifically about contributory negligence, and you know that in Virginia is one of 5 states in the country that still has the outdated notion of contributory negligence. And in where we live, Virginia, Maryland, and DC all have contrib, meaning 1% fault of the plaintiff, you get no money. And I can't tell you how big of a stick that is, and we're going to talk about why as we go through this. Because when you're assessing a case, one of the first things you want to do, you're going to listen for damages. But then at some point, you're going to have to review the medical records, and there are going to be things in those records that are far from race neutral that will impact the verdict. So these are just some of the other rules that I'm talking about, contributory negligence, because this is what's going through your head when you're thinking about, am I going to take this case? Is the client contributory negligent? Am I going to be able to survive a motion to dismiss? They come at us in every aspect of the case. Any opportunity and every opportunity to get your case tossed out and keep you from getting to the jury, defense lawyers take it. And so these are the things that you're thinking about on case selection. Is it going to be contrib? Can I survive a motion to dismiss? Can I survive summary judgment? Is there going to be a Daubert challenge to my expert on every aspect of the case? Liability, causation, damages. And then there's limits on recovery. Virginia has an overall cap for medical malpractice. So it doesn't matter if you fall and bump your head and you can no longer become this great lawyer that you're going to become as a UVA law grad, and you can never work another day in your life, and you were going to work at a big firm earning $200,000, $300,000, $400,000, $500,000 a year as a lawyer. In Virginia, if a doctor does that to you, your injury is going to be capped. And it doesn't matter how much money you're going to need to live that life, you're only going to get the cap. And that's horrible. I just settled a case in Virginia for the cap for a man that will outlive the money. And he will eventually be on Medicaid because of the cap. That's another lecture. But there are rules that impact how lawyers assess cases. So, one of them, all of this goes to this. The likelihood of a case reaching a jury influences the settlement opportunity, the value, and whether or not that case is going to be selected by a lawyer. Disparities in medical treatment and outcome. So what I do is medical malpractice litigation. So this is like major for us. So when we talk about disparities in medical treatment, I'm just going to talk big picture. Inferior treatments, patient safety issues. So you're like, well, what do you mean inferior treatment? Well, the fact of the matter is that racial and ethnic minorities often receive substandard medical care, leading to higher rates of adverse events. You're like, well, so what does that got to do with the doctor? It matters because those adverse events that they're more subject to are considered complications, risk factors, reasons why the event happened, the reason why the patient isn't entitled to compensation long term, because they already had these adverse events. High blood pressure, diabetes, heart disease, and we could talk another lecture about what causes those things or what impacts those conditions. Patient safety, a lot of ethnic minorities, black people, go to bad hospitals. Why? Because they're in their communities. and they don't have access to better hospitals. This is what I was talking about with respect to contributory negligence. So when a lawyer determines to accept a case, and you get the records, because we accept them conditionally, because we want to see what the records say. There's bias in the electronic medical records. That's principally what we see these days. And here's what I mean. They're code words and actions that describe patient conduct and behavior that will trigger an allegation or claim, a defense of contributory negligence. For example, the patient claims they're having 10 out of 10 pain. That's the worst pain ever. Claim, pain is a subjective finding. It's what you feel. Nobody can tell you, whether or not you're in pain, right? But they write things like claims 10 out of 10 pain. Reports pain disproportionate to physical findings. Refused versus unable to tolerate. That is huge. If a patient refused a recommended treatment, and it was a treatment that would have impacted the outcome of care, that's contrib. But if the patient is unable to tolerate the care, that's not. Words matter. Hysterical, difficult, resistant, challenging, non-compliant. And then my favorite, quotes, air quotes, to describe a statement by the patient. That's signaling doubts about the accuracy or the legitimacy of the patient's self-reported symptoms. And this right here, testing, you go into the hospital with a headache because you're having a stroke, an aneurysm, and they want to test you for HIV, STD, and drugs. You need an MRI. You need a CT scan. Not this crap. All right, I'm off the box. So all of that impacts contrib. So here's venue and race. Let's say you've decided to accept the case. Well, where is it going to be? The medicine says this case should be accepted. Well, for me, it's a case, the question is, yes, this is a case, but is it a case that I'm going to do? Because I'm going to tell you folks, the only time I've ever cried in court has been in the Commonwealth of Virginia, in the Eastern District. And my client and I were both crying because we couldn't figure out what the hell was happening. Why is he like that? Talking about the judge. We can't focus on that. We got to get this win. And we won, but he held the verdict down. So when I look at cases, the green places are go. The brown places, not so much, and maybe not caring. I will tell you, I partner with lawyers in Virginia. Not lawyers that look like me, white lawyers. Because there are certain places I know I shouldn't go by myself unless I have somebody with me that does not look like me, that can vouch for me. Okay? Race matters. I'm just going to put the brown names up here. I'm not saying those are places that I go and I need a white lawyer with me. I'm just saying those are places that I have cases in that I think about having a white lawyer with me. Okay? Because all is not fair in America. Judges and legislatures believe juries with many African Americans or low-income jurors tend to favor personal injury victims and award higher damages. I believe that too. That's why I like the green places. Okay. And it's simple. These are discussions lawyers are having every day right now somewhere in the Commonwealth of Virginia. This is what I really wanted to talk about. Another thing that race impacts, valuation of damages. You might think that if you lose your limbs, upper and lower, that race shouldn't matter about how you calculate my damages. You would think that if I am a mother and that I have a child and that child is born with birth injuries as a result of the manner in which the delivery happened, that my race should not matter. your race is going to matter. Because the way that we use the data that determines race, the impact of the value of the case, is race-based data. And what am I talking about? I'm talking about data by the United States government. So let me just get through these points here. Tort cases are typically not associated with civil rights, but the issue of compensation for personal injury plaintiffs is a civil rights issue. Using race-based data to calculate damage awards is a civil rights issue, as it violates the plaintiffs of colors equal protection rights under the 14th Amendment of the United States. Courts have held that such practices violate the equal protection and due process clauses of the United States Constitution. What am I talking about? So this is a chart from the United States. It's right here from the National Center for Health Statistics, National Vital Statistics System, mortality data file. So if you were to look this up, let's go back here. If you were to look this up, you'll find this chart. And what I wanted to point out were the years. So let's look here. This chart is from 1900 all the way to 2021. And I don't think that we can really seriously debate that between 1900 and 1964, that race held back black people down. Let's just say that. You know, in terms of our access to health care, justice, jobs, in all respects. And I said 1964 because I'm talking about the Civil Rights Act. And we're going to say that it made a difference. All right. So if we consider this data here, from 1900 to 1964, and we're talking about trends, 60 years of the trends is baked in racism, or the effects of racism. So here's a chart. There are lots of charts, and I just pulled this one out because it shows the difference in life expectancy. And you're like, well, why does that matter? Well, so if we're making a claim, remember I defined what is a $1 million case, and I talked about severe permanent injuries. Well, how long is permanent? Permanent is your life expectancy. You know, whether it's going to be 70 years, 60 years, 50 years, what have you. That's what we're talking about, how we measure it. So we're trying to figure out how long are you going to need the services over your lifetime. Lifetime matters. And so if you look at this chart, you'll see that white men and women tend to live longer than certainly longer than blacks. And Asians tend to live the longest. But you can see that here, for a black male, the life expectancy is 67.6 years. A white male, the life expectancy is 74.0 years. Females outlive males, so for both black and white females, the life expectancy is greater, but not as great as for those who are white. And we could talk about the issues with the Asians, but I don't want to get into that. My point is that U.S. vital statistics show lower life expectancies for black Americans compared to white Americans due to factors like high mortality rates from chronic diseases, cancer, homicide, 4% homicide, and that's a factor that is not considered in any of the other calculations of life expectancy. And then as well as disparities in access to health care and social determinants of health. You're talking about racism. All right. So, the data does not reflect an assessment of capacity. So what do I mean by capacity? Quick economic lesson. Capacity, if you think about an empty cup, the capacity is what can be held in the cup. We're talking about what you could do, not what you have done, what you could do. And with someone with your intellect, etc., that's what we mean by capacity. Here's a solution. The DC Council has passed a code that makes it illegal to use to explain that you're in personal injury or wrongful death, estimations, measures, or calculations of past, present, or future damages for lost earnings or impaired earning capacity shall not be reduced based on actual or perceived race, color, religion, national origin, sex, sexual orientation, or gender, or expression, as those terms are defined. That's a solution. Mediation in trial. When I mediate cases, particularly places where they don't know me, and when I say they, I'm talking about the decision makers. When they don't know me, the mediator does something special for me. How do I know that? Because I've talked to them. They introduce me and they give me a true bio. They want them to know that this person is competent. Because as James says, it all starts with competence. And so the racial makeup of lawyers, parties, judges, and jury can affect case outcomes, especially when race is a subtext of the case. And race is generally always a subtext of the case. So, in summary here, race influences key aspects of litigation, often in ways that are hard to detect, but deeply embedded in the system. Recognizing these disparities is important to achieve multi-million-dollar verdicts and settlements. And we talk openly about race in mediations. And last slide. I want to thank you. My granddaughter is my first and only grandbaby, thanks you. And most importantly, she says, please refer cases to my grandma. It will help my college fund.
Thank you all. Thank you, Professor Robinson, for having us and organizing everything. What I'm going to do, I'm a social scientist. I'm a psychologist by training. I study human behavior. And what I'm going to do is try to explain a little bit what happens in the black box of jury deliberations, jurors' heads, individual jury decision-making, what happens when they come together in a group, to try to explain why and how some of what James and Karen just talked about happens. Now, first, what I want to talk a little bit about is the importance of diversity on juries. So I'm going to focus on jury decision-making. There is some really interesting research on race and gender and demographics on judicial and arbitrator decision-making too. So this is human nature, right? This isn't just specific to juries. All of this is happening in judges' heads, in arbitrators' heads. It all sort of just gets all jumbled together and happens. So when we're talking about juries, so a group of more than just one, right? When it's a judge, it's just one person. In arbitration, there's one or maybe three. But in juries, what happens is when you have diverse juries, and by diversity I mean a lot of the research I'm going to focus on is race for obvious reasons, but this happens with any type of diversity depending on what the issue is, but I'm going to focus on racial diversity. So when there's racial diversity on jurors, we get better processes. So there was a really interesting study that compared how all-white juries deliberate versus racially mixed juries. And what was super interesting is that even before deliberations, jurors who were on racially mixed juries were less prone to conviction than jurors who were on all-white juries. Now, what that means is, by simply being on a racially mixed jury, they were interpreting, evaluating, weighing the credibility of the evidence differently. So their pre-deliberation opinions were different by simply being on a racially mixed jury. Their verdicts were different. So the juries of the racially mixed verdicts were different, but I'm going to talk about that in a second. Their pre-deliberation opinions were different. Their deliberations also looked differently. So racially mixed juries deliberated for longer. They remembered more of the evidence. They recalled and discussed more of the evidence, and they called each other out when they felt like jurors were relying on racial stereotypes. And so the process of how they deliberated was a better process. So there's a lot of research on how general diverse groups do make better decisions. Harvard Business Review has tons of stuff on it. But that applies to juries as well. Now, we also know that racially diverse juries produce better outcomes, fairer outcomes. So those discrepancies in conviction proneness, disappear when you have racially mixed juries, or at least are mitigated. There is research that shows that happens with death sentences. So jurors, there is a fewer propensity to give a death sentence in racially diverse juries than all white juries. That is also the case that they are less conviction-prone in non-felony criminal cases. What's also really interesting is you get the same effect when just the veneer is racially diverse. Even if the jury ends up being all white, simply having other people in the veneer has a difference in the outcomes of those juries. Why is that? The researchers believe that it's because attorneys were striking jurors based on race, not based on bias. So by striking the black jurors in the jury selection process, they were missing the jurors who were actually biased, who were white, and didn't strike the jurors they should have been striking based on trying to eliminate bias from the jury pool. So they were striking the wrong people, and I'll talk about the relationship between all of that in a minute. But so just having a racially diverse veneer eliminates some of the discrepancies, inequities, and outcome, but also on the jury itself. And then finally, more public trust. So how many people have read a newspaper article or a press piece that when talking about the outcome of a trial, they describe the racial and gender makeup of the jury, right? So a jury composed of A women, X men, X white jurors, Y non-white jurors. Why is that? It's a cue. It helps us understand whether we should trust the trial, trust the outcome. I did a study many years ago where I had potential jurors just read a summary of a trial where the jury was either all white or racially mixed, the defendant was African American, and gave them a summary of a trial and then gave them the outcome. And what we found was that when the defendant was African American and convicted, the jurors, the people who read that the jury was racially mixed, believed the trial was fairer and the outcome was fairer. So there's public perception of juries is very important. A lot of Supreme Court decisions talk about this. And so by having racially diverse juries, not only do you get a better process and more equitable outcomes, public perception of them is fairer. And right now, we've got a lot of problems with trust with our legal system and trust in a lot of our public entities in general. And so improving trust in the process and the outcome is important. Okay, so let me talk for just a quick second about how do jurors actually award damages? What is the process of how they do it? First, they take assessment of all of the facts, the parties, who the parties are, all that contributes to whether they should find liability or not. The second decision is, are damages warranted or not? That is a categorical, both of those are sort of yes or no questions, right? The third part is what these researchers who do a lot of research on damages call ordinal gist. In terms of rank, should this be a big award, a moderate award, a low award? What's their gist? What's their sort of gestalt impression? Should this be big, small, or medium? Once they make that decision, then they start constructing numbers for each of those components to ultimately produce a number that is big, small, or in the middle. And if they come together with their components and they work on all the components, if it's a damage award that includes components, then if the number feels too big, they readjust the numbers to reduce them. If it feels too small, they bulk them up. So it fits their general gist of what they think the award should be. So that's the process of what they do. What we also know from research is that there are two components that are called vertical equity and horizontal inequity. So vertical equity means the more severe injuries are, the bigger the damages are. So there is equity in terms of the amount of damages track the severity of the injury. There is inequity within the certain levels of those small, medium, or big damage awards. There's a whole bunch of variability within certain levels of damage awards. And that variability, this horizontal inequity, allows for a lot of this variability. And that is where all of the stuff that James and Karen were talking about comes in. It gets baked in this horizontal inequity, all of the different components that get pulled together when a jury is trying to figure out what an award should be. Now, jurors often tell me that determining damages is the hardest part of their job by a long shot. They have a very difficult time determining damage awards. And part of it is they don't have any benchmarks. Sometimes they get evidence that give them yardsticks or benchmarks, like for economic damages. Sometimes they don't. It's really, really difficult for them. And so that difficulty, in addition to a lot of the squishiness of the evidence about damages, allows for this big sort of nebulous, what are we supposed to consider here, decision-making process that results in this horizontal inequity. Now, what we also know from research is that evidence is by far the primary driver of verdicts. But what we also know is that experiences and attitudes are more predictive than demographics, just statistically. If you bake into like a regression analysis, all sorts of different factors of the case, and then all sorts of different demographics, and attitudes and experiences. The attitudes and experiences are what are driving, for the most part, their preference for a verdict, how they evaluate and weigh the evidence. But what I'm going to talk about is that the demographics are used as proxies for those experiences and attitudes. And all of those play into how people assess and evaluate and weigh the credibility. Now, statistically, the relationship between race and damages is not huge. It's fairly weak. It is inconsistent, but there are a few consistencies I'm going to talk about. It is often mitigated, moderated, or eliminated in some studies when you control for other factors. Why is that? It's because the demographics are proxies. Now, some of these proxies are very, very close proxies. Some of them are weaker proxies. What we're talking about is what James was talking about, which is the ability to understand and relate to an experience. Right? So to what degree does a demographic or lead to an experience or not? To what extent is an experience you have separate from everything else? All of that plays into how you weigh evidence. So for example, I find in securities cases, women tend to be much more plaintiff-friendly than men. Why is that? Is it because women tend to feel one way or another? No. What we find is that it's because women tend to not have the same kinds of financial exposure, experiences, decision-making power, CFO roles, controller roles, auditing and accounting roles than men do. And so it's that lack of experience that women have versus having those experiences, those lived experiences that men have, that allow them to identify with a defendant, understand why a defendant might have done something they did or didn't do. Having those experiences allow jurors to take in evidence, weigh evidence, assess the evidence. Do I believe this? Do I not believe this? There's some research that shows women interpret a reasonable person instruction in a sexual harassment case very differently than men do. Women decide cases in sexual harassment cases differently than men. Same with race. Why is it? I can see that behavior would be harassing, or I can see that behavior would be discriminatory because I've experienced it. I know what it feels like to have someone tell me, you can't get this promotion because of some vague explanation that has no base in reality. I know what that feels like. I've had it. I know what happens. This feels like that. This seems credible to me. Competence, credibility. It really does all come down to credibility, but how we assess and weigh credibility is all based on, as Jim was saying, who we are, our own experiences. That seems credible to me. This doesn't. I'm going to give that a lot of importance. I'm not going to give that a lot of importance. So all of these experiences are what affect how jurors weigh and assess credibility to evidence. But to a large degree, and in some cases more than others, our demographics are proxies for those experiences. And sometimes they're very, very good proxies. Now, getting to the research that we have on race and damage awards, some of the consistent findings is that non-white litigants do receive less than white litigants. And I'm sort of, the studies sort of differ not differ, but some studies focus more on white versus African American. A lot of studies also break out Hispanic, Native American, American Indian, Asian. And so I've sort of grouped together because the findings are not terribly consistent when you get down into the smaller, the different categories. So, but what is consistent is that non-white litigants receive less. Part of this is because of what Karen was talking about with the actuarial tables. So, actuarial tables function to drive damage awards down in two ways. One is it just gives them a lower number to use, right? A lower anchor. The other way is it gives people cover. If people feel like they want to drive down damages, I don't want to say why I'm driving down damages, or that number sounds more credible to me than this number, that unconscious bias. Actuarial tables, and there have been a couple studies that statistically pull out at the use of actuarial tables and damage awards, they account for a portion of the variability in why non-white litigants receive less. Not all of it, but certainly a portion of it. So there's some good research, Karen, that backs up exactly what you were talking about with the actuarial tables. There is also research that shows non-white jurors give more in damage awards than white jurors. There's also research that shows jurors award less damages, lower damages against non-white defendants. But when they follow up on why, some of the follow-up research shows that that's mostly driven by defendant wealth. So how much the defendant has dictates to some degree how much they award. So this is really, again, a proxy, right? It's wealth, not necessarily the characteristics of the defendant themselves, but it's part of it. There is also some research that shows attorney and juror similarities result in larger damage awards. So there's something called the affinity bias. I like and believe more credible evidence that's coming from someone like me. But the effect sizes for these are relatively small, 2 to 15% in the variability. They're most prevalent in discrimination and personal injury cases and non-economic damages. Why is that? Implicit bias is why. Implicit bias comes out, its playground is in ambiguity. When there is ambiguity in decisions, like what do I award for non-economic damages versus economic damages? Things like, is there contributory negligence? When they've got some wiggle room there, I might be more or less motivated to drop a number in there than not. All of those ambiguities, less concrete decisions, more space for discretion, and high cognitive pressure. So when any of us are under a lot of pressure, we make quick, stereotypically based decisions. It's human nature. Daniel Kahneman has done decades and decades of research on this. And jurors are always under high cognitive pressure. So that discretion is where all those biases sneak in to help to produce these effects. Now, what mitigates some of these effects of race? One is getting back to jury diversity and deliberation. So a lot of studies show these pre-deliberation discrepancies either reduce or go away after deliberations. Jurors are very good police people of each other. They check each other. We check ourselves when we know there's someone in the room who might call us out. So diversity in deliberations reduces those effects. Again, getting back to attitudes and experience, when that's really what's driving the decision. So studies that have looked at attitudes plus demographics, the demographics tend to fall out as not being statistically related. It's the experiences. But when they're really close proxies, they don't drop out. Real life settings, so as James was talking about, competence, the real world of a big, long, complicated trial can make some of the factors in these academic research studies fall out, and then other factors that drive damage decisions. So there's lots of research about other factors that drive damage awards. These tend to be bigger effects than race or gender or demographics, but they are sometimes connected to each other and proxies for one another. So there are characteristics of the case: severity of the injury, plaintiff and defense anchors. Does the plaintiff offer a number and the defendant offer their own number? What is the strength of the liability case? The stronger the plaintiff case, the less effect of race on damages there is. There's a bigger effect when the case is very ambiguous. If you've got a slam dunk case, there's less wiggle room for this stuff to play a role. defendant conduct, type of defendant. Is it an entity versus an individual? What is their wealth? And then there are juror characteristics. So anti-corporate bias, skepticism towards litigation, numeracy and financial literacy. There's research shows that those play a role in damage awards. Entrepreneurial background, decision-making style. Are they emotional decision makers? Are they analytical decision makers? Locus of control, which is a thing about how do we attribute cause and blame. And then belief in a just world. So those are the these are very good drivers and predictors of damage awards in general. Some of these have demographics that are very good proxies for them, and some of them don't. So when you're talking about all of this stuff, what we're talking about is what's actually related, what are proxies, what's tied to the experiences, is race tied to the experience, is it a mediator or a moderator? So it's complicated.